So what is comparative negligence? Comparative negligence is a Florida law, and it's not a law shared in all states. This is a law that Florida and some other states have. But basically, comparative negligence allows for a jury or an insurance adjuster or the parties involved to accept the possibility that an accident may not be entirely one side or the other's fault. It could be both people's fault. We see arguments of comparative negligence often come up in slip and fall accidents. So let me use that as an example. Let's say one of our clients is walking in a department store and there's a spill on the floor and they didn't see it. Maybe they should have, but they walk through it, they fall, and they hurt themselves. Well, obviously, you hire Trial Pro. We're going to be doing everything we can from the very beginning to position your case so that we can argue as forcefully as possible that the store was responsible for that dangerous condition. Either they created that dangerous condition and caused that spill on the floor. Maybe that spill had been on the floor for 20 minutes and they didn't have enough people walking the aisles to make sure that everything was clean. And if they had been doing a reasonable job of inspecting their floors, they would have noticed it and cleaned it up so they could have better protected customers, including our client who just fell there. So we're going to do everything we can to try to argue that the fall was 100% the fault of that store. At the same time, in all likelihood, they're going to push back and they're going to say that, well, if our client had been paying more attention and at least watching where she was going, she should have noticed this big red puddle of fruit juice on the floor. And if she had been paying more attention herself, she could have avoided this accident. The reality is we can go back and forth arguing about who's at fault and to what percentage they're at fault. We're never going to agree on that issue, and we probably shouldn't, because ultimately the only person who can decide that issue is a jury if it goes as far as actually getting a verdict for a jury. But what would end up happening hypothetically is you take that type of case to a trial, a jury could come back and say that the defendant was 80% at fault for not cleaning the store, but our client was also 20% at fault for not paying more attention. And if that's the jury's findings and they award our client $100,000, that verdict gets reduced by the percentage our client was at fault. So that verdict of $100,000 would get reduced by 20%, and the net judgment would be $80,000. If that jury came back and said the store was 50% at fault and our client was 50% at fault, just for the sake of easy math, again, if they said the damages were worth $100,000 in that scenario, it would be reduced by the percentage our client was at fault, which is 50% in this example, and the verdict, the net judgment would be $50,000. So that's the nutshell of how comparative negligence works in the state of Florida. Doesn't come into play in most types of car accidents. You know, obviously if you're rear-ended or if someone blows through a stop sign or a red light, they're 100% at fault. Sometimes though, when you have crashes that are he said, she said accidents and there's a disagreement about who had the right of way or which lane this impact occurred in, and there's no way to sort of figure out determinatively who's telling the truth, that's a situation where there may be comparative negligence taken into account. So if you have questions about how comparative negligence works in general or with your case specifically, feel free to call 1-800-TRIAL-PRO or chat with us live at trialpro.com.